Welcome back. My name is Markus Wesaw, and again I will be your facilitator for this presentation entitled, What is OSHA? An Introduction to Health and Safety. This will be the second part of this series, and we will begin the discussion by going into a survey of the differences and similarities between state-run OSHA programs and federal-run OSHA programs. The issue pertaining to OSHA and the states versus federal government is best described as an initiative to preserve state rights. See, we can turn on the news almost any day and see some type of lawsuit or other form of public debate pertaining to state powers versus federal powers within our government. For example, only the federal government can declare war on other nations and coin money in the mint. State governments have been allowed to prevail over state powers, such as the most recent legalization of recreational marijuana. Some states have determined that the interests of the state can best be served by maintaining a state OSHA program. States like Wyoming, Utah, and Oregon have adopted a state OSHA plan, and worker safety and health issues are enforced at the state government level. Other states, such as Colorado, North Dakota, and Montana, have elected to forego a state-run program and therefore have worker safety and health issues enforced by the federal government. It is also important to note that any state-run OSHA program must be equally effective as the standards and regulations outlined by federal OSHA, except in certain cases, such as Wyoming not having a maritime regulation because they are inapplicable. There are quite a few major differences between state-run and federal-run OSHA programs. State OSHA programs, again, have the authority to eliminate standards and regulations where they are inapplicable, such as Wyoming's program, whereby the maritime standards were excluded. Another great example lies within Wyoming as well, where we see that due to the predominance of oil and gas well drilling operations, Wyoming OSHA raised the bar and created regulations and standards specifically for the oil and gas industry within the state. This is an excellent exemplar of how a state OSHA program can make its own regulations and standards more stringent if it deems necessary to do so. Finally, state-run OSHA programs, generally speaking, lack the necessary funding and manpower to effectively cover the entire state's jurisdiction. However, in all fairness, an argument can be made that federal-run OSHA programs have a similar predicament. Generally speaking, federal-run OSHA programs are well-staffed and well-funded. Another major difference is that federal-run OSHA program enforcement citations are federal offenses, and disputes not settled internally with OSHA could lead to federal court hearings with the Occupational Safety and Health Review Commission, or the OSHRC. Federal OSHA creates standards and regulations for occupational health and safety that tend to horizontally address worker safety rather than focusing upon state-specific worker safety issues. Finally, federal-run OSHA programs have access to a wide array of federal resources that probably make federal OSHA slightly more intimidating than a state-run program. But of course, that is simply an opinion. The list of states presented on your screen outline those states with an approved OSHA program. In these states, the state government maintains its own state-run OSHA program that must remain equally as effective as federal OSHA. However, I would be remiss if I didn't cover Connecticut, Illinois, New Jersey, New York, and the Virgin Islands. These 5 locations maintain both a federal-run and state-run OSHA program. You may be asking yourself why this might be, and that is an excellent question, so I will elaborate. In these states and territories, state-funded projects will fall under the jurisdiction of the state-run OSHA program. Private companies and industries that are outside of state funding will be covered under the jurisdiction of federal OSHA. So, essentially, these states and territories maintain both a state-run and federal-run OSHA program. In order to determine jurisdiction, it is necessary to figure out whether or not a company is working for or under the state or territorial government. If the answer is yes, then the state-run OSHA program would maintain jurisdiction, and if not, the federal-run OSHA program would maintain jurisdiction. This jurisdictional issue can indeed get even trickier for the maritime industry, but we will leave it at that for now. Is your state on this list? If so, your state has an approved state-run OSHA program. Presented on your screen now are all of the states who follow the federal guidelines only and, as such, are federal-run OSHA programs. Is your state listed on the screen? If yes, then your state too is an OSHA program run by the federal government. Moving on, I want to now discuss with you the various complexities of OSHA regulations in general. There are predominantly 4 prime areas of OSHA standards and regulations, which are the general industry, construction industry, agriculture industry, and the maritime industry. However, if one wants to look at where the focus is within OSHA as an agency, one would find that based upon enforcement activities, such as citations and penalties, that the emphasis is placed upon both the general industry and construction industry as a whole. Looking at the number of maritime citations issued in 2013, we find those to be of a very minute percentage compared to general industry and construction, which is why we can draw this conclusion with pretty decent certitude. That being said, the emphasis upon general industry and construction standards, employers are directed to respond to these regulations by way of compliance. A tricky part about maintaining compliance with OSHA regulations and standards can be derived from a confusion between general industry and construction standards. Moreover, many employers are under the impression that their work activities fall under the general industry, yet find that during an OSHA compliance inspection, construction standards are enforced. Similarly, employers within the construction industry are frequently cited for violating general industry standards. As a general rule of thumb, I recommend to my corporate clients that they survey the work being performed within the workplace and design an effective health and safety program, including elements such as training and hazard recognition, in accordance with the most stringent safety and health regulations between construction and general industry. Furthermore, I will add that many of the maritime industry regulations are incorporated by reference, such as respiratory protection requirements. The point that I am trying to make here is that one has to be cognizant of the OSHA regulations that apply throughout various industries in order to be most effective. Now that we fully understand the differences and similarities between federal-run and state-run OSHA programs, as well as the fact that there are 4 prime industries regulated within OSHA, let us take a quick moment to further delve into the definition of construction. OSHA defines construction as construction, alteration, and/or repair, including painting and decorating. Now, any of you who may have had an English class or two in the past, you are well aware of the fact that we are not supposed to use the word we are defining in its own definition. But that is what OSHA has done with the definition of construction. Therefore, I feel the need to elaborate on what construction is, and I present the idea or concept of construction as the building or designing of something new. For example, a company may be building an addition onto a residential construction project where a structure is being added to another larger structure. At least, this is how I view construction as a starting point. I think what is interesting about this definition of construction is the fact that painting is considered construction work. Those working predominantly within the general industry probably paint quite a bit because it is a very common maintenance task. If painting is occurring within a particular workplace, that is indeed considered construction work, despite whether or not a company engages in the traditional concept or idea of construction work. I think that as a participant, you are beginning to understand that safety regulations can be a bit convoluted if you are not in the loop entirely. As you can probably imagine, the work that you are doing determines what type of OSHA regulations apply and do not apply. As you have probably heard many times, knowledge is power, and although this is a very overused statement, knowing how to use the OSHA standards to your benefit creates quite the proposition. Here are my 4 general recommendations for promoting health and safety in the workplace, as well as staying compliant with OSHA. Employers should have a thorough knowledge and understanding of both construction and general industry safety regulations. Employers should train their employees on maintaining compliance with the most stringent OSHA regulations. Employers should reassess safety standards to reflect the actual work being performed rather than operating under the mistaken belief that only one set of regulations apply. Employers should identify risks and hazards in the workplace and use the appropriate OSHA standards to ensure proper employee safety and health in the workplace. Once an employer can fully understand how the OSHA regulations apply to their company, the likelihood of regulatory compliance and an effective safety and health program are significantly enhanced. You have reached the end of the second part within this series. This presentation has been produced by MW Consulting LLC. Feel at liberty to contact us directly with any questions or comments. Thank you.